Good afternoon, Mr. Chairperson, Honorable Mr. Anura Disnayaka, ladies and gentlemen. First of all, I must apologize for not speaking in Sinhala, although I can understand little Sinhala if it is something related to politics only. So my knowledge is very much limited to politics, but since we are lawyers, we must be very careful about the words what we are using. So I don't want to take the risk of speaking in Sinhala about some legal issues and legal concepts. That's why I prefer to speak in English. First of all, I would like to thank the organizers for giving me the opportunity to share some of my thoughts with you in this evening on the executive presidential system, with particular reference to the 18th Amendment to the Constitution. And as requested by the chairperson, I will use very simple English, knowing that that would be easy for you to understand, to comprehend the legal implications. These two issues, executive presidential system and the 18th Amendment, these are not new topics at all. For example, on the presidential system, right from the beginning in 1978, volumes of books have been written criticizing the executive presidential system that was introduced to this country by the 1978 Constitution. At the time, as referred to by my friend Dr. Jayampathy Vikramaratne, some of the minority parties and some of the Tamil legal scholars supported the idea of the executive presidential system, saying it would be better if you have an elected president to resolve the ethnic conflict in the country. So it is better to, relatively compare with the parliamentary system, it is easy to resolve the dispute under the executive presidential system, because the executive president needs the votes of the minorities as well. Therefore, seeking a political solution under the presidential system would be much easier. This was the argument put forward by some of the leading Tamil scholars at the time. But even at the time, I was a very young lecturer at the faculty. It was, I think, in my first year at the faculty as a teacher. We actually opposed, and we said it cannot be looked into from that particular angle, whether it would be easier to resolve the dispute under the presidential system, but it must be looked into from a larger or broader perspective, how it would actually undermine the democratic process in the country, looking at from constitutional principles. So we objected or registered our vehement opposition to the executive presidential system right from the beginning. My friend Mr. Jayampathy Vikramaratne stated that whether it is possible to demand the abolition of the executive presidential system at all at the moment, or creating a democratic space and from there try to move on. In principle, I would say my personal opinion is I am not for this reformed executive presidential system or reducing the powers of the executive president, thereby having decreased power of the executive president and increased powers with the parliament. In my personal view, I am not in support of that position. I am for the complete abolition of the executive presidential system from the country. Usually we share these thoughts and argue with our students in the classroom. We don't actually discuss this in public meetings like, right, have an audience like this. Now this executive presidential system we are talking of, now nowhere it is defined that what is meant by the executive powers. Where do you find what is this executive power that we are talking of? The person who exercises the executive power is known as, or in Sri Lankan context we call as the executive president. But what do you mean by these executive powers? So I was searching for that from various constitutional law books, and I found in one case, in the Indian case, in 1964, the Indian Supreme Court defined it. And it's very interesting. The Supreme Court said in 1964, executive powers are the residual powers. The meaning is, some powers are for Parliament, some powers are for the judiciary, and whatever left then, that is not given to Parliament, not given to the judiciary, whatever the leftover, the balance, that power should be called executive powers. So you can't say A, B, C, this is executive power, this is executive power, you can't say that. It is very difficult to define that, but whatever that is left over, not designed to, not given to Parliament, not given to the judiciary, then it should actually be considered as the executive power. But when we got this executive presidential system under the 1978 Constitution, then what happened was, it is completely the other way around. All the powers were taken by the executive president, and whatever left over, that was given to Parliament, and the balance was given to the judiciary. The dilemma is that it's a complete reversal of constitutional principles, the understanding of democratic principles. What should be the balanced powers given to the executive residual powers? Now in the case of Sri Lanka, the executive powers actually dominate all the other two sections, other two branches of the government, and the residual powers to be found with the legislature and the judiciary. But the way the political system operates, I am not a politician, but my academic view is that the way the political system operates in this country clearly has proved even that residual powers left over to Parliament and judiciary is not at all exercised or not at all to be used by those with whom those powers are entrusted with. For example, the Parliament cannot act the way in which it wants. My friend Jayampati earlier said that Parliament can be dissolved at any time after 1 year from the date of the election. Parliament can be dissolved at any time by the President without giving any reasons why Parliament should be dissolved. So we say that the President may have a bad dream in the previous night and gets up in the morning and say, I dissolve Parliament. Reason, who knows why Parliament should be dissolved. Our Constitution provides for that situation. You don't need to give any reasons. Similarly, proclaiming emergency regulations, invoking the provisions of the Public Security Ordinance, it is in the hands of the President. And why you should proclaim emergency regulations? Why should invoke the provisions of the Public Security Ordinance? As it is, you don't need to give any reasons. So as I mentioned earlier, President may have some dreams in the night, gets up in the morning and say, proclaim emergency. This is what I had in my dream. Something is going to happen. I am certain about it. And where do you go? Where do you go and challenge the proclamation of emergency is against the law? It is against the Constitution. How do you challenge it? There is no provision in the Constitution. So that is why I say at the beginning, it is not the reform executive presidential system that we should look for. We should actually demand or work towards abolishing the presidential system completely. In the Sri Lankan context, when we adopted this executive presidential system, this is what J.R. Jayawardena stated in the National State Assembly when he moved the Second Amendment to the 1972 Constitution. Thereby he has become the executive president. This is what he said. This is to the rapid economic development demanded by the people. In order to facilitate the rapid economic development demanded by the people. And also he said that I need sufficient time to implement the programs without giving in to party politics in Parliament. So I don't want to be dictated by Parliament, defeating whatever that I wanted to implement. Now, in today's context, you may think about it. Is it for the rapid economic development and is it demanded by the people? Question number one. Question number two, whether these programs being hindered or prevented because of party politics, because Parliament is divided according to party line and thereby programs have been hindered. Is it possible for us to argue that this is why we want, people demand that the executive presidential system should continue? Another interesting point that I would like to make is that this is what earlier Dr. N.M. Pereira as well as Dr. Colina de Silva wrote actually, criticizing the 1978 Constitution. I think all of you are aware, but you had to put all these things together and consider. Now the president under the executive presidential system, as the Constitution says, president is the head of the state. Again, president is the head of the government. Third, president is a member of the cabinet and is the head of the cabinet. President is the head of state, president is the head of the government, president is the head of the cabinet, then president is the commander-in-chief of the armed forces. Fourth one. Fifth one, president can be the leader of a political party as well. So my friend Jayapati was talking about Ronald Reagan, right, the powerful American president, etc. But in our analysis, we have compared the various constitutions where this presidential system available, and in those states which actually claim themselves as democratic states. Any state which claims itself as a democratic state, you compare the powers of the executive president of Sri Lanka is having, we can say, in any democratic state, the Sri Lankan president is the most powerful political authority in the world. It's not an American president. It is not a French president. There are constitutional limitations imposed on them, and those limitations are not available in the case of the executive presidential system in this country. You may very well aware that sometimes back, there was a constitutional issue arose in the US at the time of the presidential election. The junior George Bush contested on the Republican side, and Al Gore contested against him on the side of the Democratic Party. And there was some issues about the electoral votes obtained by Al Gore, Senator Al Gore, in the state of Texas. And the state of Texas, the governor of the state of Texas was the own brother of the other candidate, George Bush. And there was some problems in counting the votes there as well. So finally, it was declared that George Bush won the elections. Then it was challenged in the Supreme Court, American Supreme Court. The court said, we don't accept the results given by the electoral process arising from that. But finally, the Supreme Court decided who should be the president of the US. And although the judgment was criticized, In fact, it was the Supreme Court finally choose the president. So can we say the president of the US is more powerful than anyone in the world? No, he had to listen to the Supreme Court. Supreme Court finally chose the president in the US. In France, simple example I can give you, in France, if you are elected as a member of the cabinet, then you must resign from your legislature, parliamentary seat. In France, it's called as National Assembly. You had to immediately resign from National Assembly if you are going to be a member of the cabinet. And the French president cannot dissolve National Assembly without consulting the Prime Minister. I have told you in Sri Lanka, President can dissolve Parliament without asking anyone. So who is more powerful? Is the French President or the Sri Lankan President? Earlier example I gave you, Senate can control the actions of the American President. The House of Representatives can move certain bills that may actually control the powers of the American President, irrespective of whatever the party that they belong to. In America, in the US, President cannot appoint judges to the Supreme Court. President cannot appoint judges to the Supreme Court, the American President, without the two-thirds support of the Senate, the approval by the Senate. Two-thirds majority of the Senate should support that appointment. So who is more powerful in the world if it is to be claimed as a democratic state? In the Sri Lankan context, Sri Lankan president can appoint anyone to the Supreme Court. Earlier we used to make it as a joke, even if the president wants, he or she can appoint his or her driver to the Supreme Court. There's no barrier. Constitutionally, there is no barrier. Because Constitution says President can appoint anyone to the Supreme Court. So the 17th Amendment at least try to attempt to introduce certain restrictions on the exercise of the presidential powers. For example, if you want to appoint someone to the Supreme Court, recommendation to be sought from the Constitutional Council under the 17th Amendment. On the recommendation of the Constitutional Council only, the President can appoint judges to the Supreme Court. That was under the 17th Amendment. What happened? In 2010, by the introduction of the 18th Amendment, those provisions were removed, repealed, and replaced with new provisions that actually provides for Parliamentary Advisory Council. President is not bound by the advice given by the Council. So still, President can appoint anyone to the appellate courts. Now, Mr. Jayampathy Vikramananda gave one example, the appointment made by the President yesterday. President is not bound to consult anyone, not bound by any legal provisions, not to listen to any recommendations made by anyone. Now, the person is suitable or not, that is a different issue. Now, the other point that I would like to stress is the famous Greek philosopher, all of you would have heard about him, Plato. He was very much against this democratic system because of the way the Senate in Greece, the Senate actually functioned at the time, and when they decided to convict, to punish his teacher, Plato's teacher, Socrates, he was sentenced to death by the Senate, the Greek Senate, through a majority decision, democratic decision. So Plato, being the disciple of Socrates, he was very much against this democratic system, and he named this democratic system, he said, democracy is a mob rule. Democracy is a mob rule because no one knows what they are doing. It's a gathering, it's a group of people, they try to rule without knowing what they are doing. So it's a mob rule. in today's context, democracy, in order to take it from that mob rule to the people's rule, there should be what we say the rule of law. Rule of law. What is the essential feature of rule of law? The basic principle is the ruler is subject to the rule. The lawmaker is subject to the law. No one is above the law, that we all of us we are aware of. No one is above the law, meaning including the ruler. Ruler is subject to the rule. I think Mr. Sunil Vattakala read Article 35 of the Constitution, which clearly says the ruler is not subject to the rule in our Constitution. So are we going, reversing back towards what Plato said? Because there is no rule of law as far as the ruler is concerned. A simple example I give you. Now, we all of us are not saints. We are not saints. If all the people are saints, then you don't need a ruler. You don't need to be governed. You don't need to be ruled because you know how to behave. All of us are very good people. No one actually needs to advise us. We know how to conduct ourselves. So if we are saints, we don't need a ruler. On the other hand, if the ruler is a saint, then we don't need any rule. We don't need any rule. And we will accept without any problem that we are not saints. People are not saints. Similarly, the ruler also not a saint. Whether the ruler of this country or any country in the world, rulers are also not saints. They are human beings. They are human beings. That is why we need rules. That is why we need rules. So in that sense, rule should be always above all, above the ruled and above the ruler, above the ruler. So now in the major problem with the 1978 Constitution is the presidential system. The executive president is actually positioned above the law, above the rule. So it clearly undermines the principle of rule of law. Right? The principle of no one is above the law. This Article 35 of the Constitution, there are two aspects in that. One is the President is above the law as far as his official actions are concerned. That of course we can understand. In some countries, including the US, this immunity is given to the ruler for any actions, official actions done during the period of his tenure, while he is in office, in an official capacity. But it is very strange in our Constitution, Article 35(1) says, this immunity is given to the President not only for official actions, but also for private actions, as long as he is in office. So this immunity is extended to private actions as well. As I told you earlier, people are not saints, the rulers are also not saints. So if this immunity is extended to private actions, what would be the outcome of it? What would be the consequences? I always give two examples to my students. It would be interesting for them actually, right? One is you go to a supermarket. Right now you have this self-service system and all. You go to the supermarket, you pick up whatever you want, and then you go to the counter and say, I am not going to pay you. I am the president. I am not going to pay you. What can be done? That purchase is for official purpose. You can buy anything and you say, I am not going to pay. Definitely it's a private action. But according to Article 35(1), person is immune. That is one. Second point is, Now, say another interesting point I would like to state, example for private actions. If you marry the second time while the first marriage is still valid, if you marry for the second time, it is called as bigamy in law, and in Sri Lanka it is an offence. The penal code defines bigamy, and accordingly it is an offence if you marry second time while the first marriage still remains valid. So the person holding the post of executive president in Sri Lanka marries second time while the first marriage remains valid. What can be done? Legally nothing can be done. Legally nothing can be done. Because all his official and private actions, no action can be filed or sued against the president as long as the person is in office, whether he or she. I am not attributing anything to individual, it is to the office of president. Nothing can be done. So it is very strange why this immunity is given to private actions of the president. In addition to that, if you look at the title, the Constitution, which says, it is the Constitution of the Democratic Socialist Republic of Sri Lanka. I don't know what J.R. Jayawardena meant by is also be a Socialist Republic of Sri Lanka. But the Constitution says it is a Democratic Socialist Republic of Sri Lanka. So what are those basic principles of democracy? The Constitution in its preamble says about it. People have ratified the immutable. Immutable means cannot be violated, cannot be breached. Immutable republican principles. It is stated in the preamble, the very first page of the Constitution. It is stated there. Then, what about the basic characteristics of democracy? The basic characteristic of democracy. The point I would like to stress is here, in any democracy, some of these examples I have already referred to, in any democracy, you cannot afford to have absolute power in the hands of anyone, any individual, any political entity. You cannot afford to have absolute power. That is anathema, that is against the basic principles of democracy. Constitution title says it is the Democratic Socialist Republic of Sri Lanka. Now let's see a simple question that we may ask ourselves. You ask your child whether that child wants absolute power to be exercised over him or over her by its parents. Do the child, your children, right? Do your children like absolute control by yourself? Do they like to be controlled by you all the time? They hate this absolute power. You ask your spouse, whether husband or wife, you ask your spouse whether that person accepts the exercise of absolute power over him or over her. Absolute power. So it is totally against the human nature, tolerating absolute power being exercised over them by a fellow human being, whether it is a father, mother, husband or wife. Absolute power being exercised over someone by a fellow human being. But when it comes to politics, exercising political authority, absolute political authority, being exercised by one single person or a political body, entity over the entire populace, over the people, absolute power. This is, it says rule of law and absolute power, absolute authority are born enemies, If you have absolute power in the hands of one person, there won't be rule of law. And if you have rule of law, then no one can have absolute power. No one can have absolute authority. These are born enemies, rule of law and absolute power. But if you look at the provisions, the executive presidential system, the provisions of the Constitution, which actually facilitates, enables to the exercise of absolute power by the executive president. Absolute power, making appointments, exercising, dissolving parliament, deciding the number of portfolios, ministries, ministers, the different titles that you are having. Right? During A.R. Jayawardena's time, we had 3 or 4 categories of ministers. Now we are having some senior ministers, I think, right? Nowhere it is defined what is meant by seniority. Senior ministers. President can decide how many ministers that I am going to appoint. President can decide how many ministries that I am going to create. President can decide which ministry that I am going to take over. I shall be the minister of this and that. And tomorrow, I can change those ministers. No one knows. You go and sleep as a minister of X today, and when you get up tomorrow, you will be the minister of Y. And you don't know why. This is the result of the exercise of absolute power. Absolute power. Constitutionally, it's very dangerous one in the context of the so-called 3 branches of the government. Friend Jayambati referred to the separation of powers. Now, by exercising this particular power, the number of ministries, number of portfolios, the number of ministers that I appoint, I can convert the legislature, the parliament, as the executive, as the cabinet. Earlier I told you what is the meaning of executive powers. So it's very obvious. It has been done more than once in this country. Now how much, so what is the majority that you need in parliament today in order to get that 50% or 51% majority in parliament out of 225, right? If you get 113 votes in parliament, right, you can form the government. So I appoint 113 ministers. So I can enjoy majority in parliament. So that is okay. That's not a problem. Problem is when I appoint 113 ministers, parliament becomes executive. Where is the separation of powers between the executive and the legislature? When they come to the cabinet, there will be 113 cabinet members. When they go to parliament, the same 113 are members of parliament. Do they exercise the legislative power or do they exercise the executive power? So the president has been given the power indirectly to convert the legislature as the executive. This is one of the examples of using this absolute power, because I have been given that absolute power to determine what should be the number of portfolios. And that is 113. If you want, then you can appoint deputy ministers and increase it further. So the 17th amendment, as I have observed earlier, at least attempted to democratize, I would say, democratize the presidential powers. Presidential powers, absolute powers given. But to give some democratic face to that, democratizing the absolute powers given to the executive president of this country. But with the repeal of that 17th amendment, by the introduction of the 18th amendment, it has become, the constitution has become more and more undemocratic. Undemocratic features have been introduced. Now finally, I would like to come to this, the term, right, the tenure, 6 years. J.R. Jayawardena introduced the 3rd amendment to the constitution, Thereby the fixed term of 6 years have been made as flexible. That means after 4 years of his tenure, he can go for the next election. Now with the introduction of the 18th Amendment, now there are certain technical issues that we have to focus our attention on. Now, when the third amendment was introduced, it is for the first time president. It is for the first time president who can, after 4 years, call for the next election. It is for the first time president. Because after 4 years of his term, if he goes for the second term, he wins, okay. But then he cannot contest for the third time. He cannot contest for the third time. Therefore, only during the first term, he can face the elections immediately after completing 4 years. Because the second time doing the same trick will not arise, because you cannot go for the third term. Now with the introduction of the 18th Amendment, possibility of what you call this, the choice of the date, any time, whether first time, second time or third time, you complete 4 years of your term, then you go for the next election. So the original intention of calling for the elections after completing 4 years, it's meant for the first term president. It is not for the second time, cannot be used for the second time. But when you repeal the term limit, now it is extended forever. I don't know if the former Chief Justice Sarath Silva has focused something on this, right? Whether now there's a conflict between the third and the 18th Amendment, third amendment as well as the 18th Amendment. Now it is extended. You can actually go for any time. Any times means any number of times you can face the elections. And also, any time after 4 years of your term, you actually face the elections. So in principle, it is totally against the democratic values. That is one. Second, I think the CRM at the time of the introduction of the 18th Amendment, the civil rights movement issued a statement. Removing that limits, term limits, may lead to a lifetime presidency. Anytime you can contest, forever you remain. Okay, anyway, that is subject to the verdict of the people. But at the same time, you read it with Article 35, what Mr. Sunil Vattakula referred to, then it is for lifetime immunity also. Your official actions, your private actions, you are immune as long as you are in office. So you see that I am in office forever. So I am immune forever. That danger should be actually brought to the notice of the electorate, of the people who vote. In any democracy, I told you, we are not saints. People are not saints. Rulers are not saints. So to what, right, on earth, we decide that people should be given immunity forever. And this limiting the terms, I told you, whether your child or whether your spouse is willing to be controlled by you by the exercise of absolute power. Okay, this absolute power exercise, at least for 12 years, as it was. Now, that limitation is removed, has been removed. So, finally, I would like to comment on what Mr. Jayampati said. From here, we have to move on. We have to move on. I told you that democracy should remain as a mob rule, or democracy should be the rule of the people. Rule of the people. So you ask yourself, you ask your neighbor, you ask your friends, to what extent you condone, to what extent you are willing to accept the exercise of absolute power, nothing else, nothing else. To what extent you are willing to accept, tolerate, condone the exercise of absolute power, which your child doesn't like, which your spouse doesn't like, which you want the people of this country to condone, tolerate, and accept forever. Thank you very much.